Please, my Lord, my name is ERNEST. I want to address a number of elements of both law and fact. And perhaps we can start by agreeing that the Constitution is supreme law in this country.
It is.
And further, that it is binding on all persons and all authorities.
Yes, it is.
Just to be specific, it's binding on the court, it's binding on the office of the GPP, it's binding on all of them.
Yes, please.
Now, the same Constitution, again, I hope you can agree on this, also provides that there are some rights from which there cannot be derogation.
True.
And again, to be specific, the wording is in Article 44, which I'm sure you're familiar with.
True. Perhaps another area that we can agree on in criminal matters, the burden of proof is on the state. True.
And we also agree on the standard that is required.
True.
Again, to be specific, the standard is beyond reasonable doubt, correct?
True.
So even in this application, the burden is on the state and the standard is what we have stated, correct?
The standard in this particular application is not beyond reasonable doubt. It is on the balance of probabilities.
Could we perhaps agree that if you want the court to believe something, the burden is on you to satisfy the court about that thing?
Yes.
Again, let's be specific. There is a section in the Evidence Act. I think it's 103. If I may just read it to you. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it's provided by any law that the proof of that fact shall lie on a particular person. So we agree, I hope, that in this case, the burden to prove the basis of the application lies on the applicant.
True.
The affidavits that you have deponed, there are 4 in total. All of them say that whatever you have stated there is based on your knowledge. Again, you just confirm that you are not basing on information, you are not basing on belief.
Knowledge.
Also, maybe just confirm as we start that you had access to the affidavits in reply of all the respondents. You read them, you understood them, and in fact you offered some responses
Yes.
to all of them.
Yes.
So the basis, now just go to the basis of the application, is a number of things that you say. You say there is a high likelihood of interference with the witnesses. Then the
nature of offense.
no, don't go ahead with me. Just stay with me. Stay with me. If you just go to paragraph 10 of your affidavit, in support. I think we shared a bundle. This one, this one. Yeah, I think that's fine. So you have copy. If you just go to your paragraph 10, you say,
Hold it.
paragraph 10.
Yes.
We are just trying to understand the basis.
Yes.
So you say there is a high likelihood of interference.
Yes.
And when you say high likelihood, you are talking about a degree of interference.
Potential. Interference.
So you are talking about a possibility.
Yes.
And in this particular case for interference, you have put the possibility as high.
Yes.
In the same paragraph, you refer to intimidation and harm as the other
Yes.
basis for this
Yes.
application.
Yes.
And for those other two, the intimidation and the harm, you have not provided any degree. So the high degree is in relation to interference.
My Lord,
Just agree.
we have no.
No.
It is one sentence, and we provide. We said it is all high.
Have no fear. You can say it is all high.
It is all high.
All I'm asking you, that as far as intimidation and harm is concerned, you have not expressly classified the degree. If you feel that you have, you can say so.
We
I am
have.
putting it to you that you have.
And I'm saying that I have.
You make reference in that same paragraph to loved ones. Correct? Would I be correct to say that that phrase includes spouses,
Yes.
children,
Yes.
friends,
Yes.
parents?
Yes.
Do we say even business associates? Would it
Yeah,
go to
they are
that
loved
extent?
ones.
They are all loved ones. Maybe co-workers. So it's a broad.
My Lord, we said loved ones.
Is it? I'm asking to understand what
Loved
what you
one.
meant.
Loved ones means immediate relatives.
So,
Immediate.
so now help us to break that. I was trying to suggest to you what it means.
Immediate
So
relatives.
such as
Children, spouse.
what's no children,
Yes.
spouse,
Yes. Brother, sister.
okay, siblings.
Siblings.
Let's call them siblings.
Yes. Maybe grandparents, auntie,
So
uncle.
parents, grandparents, aunties, uncles. It's an extended family situation.
Yes.
Now, have you interacted with any of those categories of people
in relation to these 6
No.
witnesses?
I have not.
So again, the mention of loved ones and the possibility is a view that is important, not one that is based on interacting with those people.
Yes.
Now, do you agree with this statement? I want to suggest to you something that might be useful as we go ahead. Do you agree that in the constitutional democracy, all legality flows from the Constitution?
True.
And also that whatever acts we do should be lawfully within the confines of the Constitution.
Yes.
So I want to go to the, I think it's paragraph 7. Just look there. It's an area that arose. It's the one I'm just calling security threats. That general space there. So paragraph 7, paragraph 7 is the same. They have done and we will look at 7, we will look at 8. Again, to just make an assessment. So we have 6 witnesses that are the subject of this application.
Yes.
And in paragraph 7, the security threat is against all the 6.
Yes.
In paragraph 8, the security threat is against one of the witnesses.
My Lord, I explained this.
We're just reading your statement. You state in paragraph 7, it's against all the 6.
One and his associate.
And then,
And the associate.
well, it says against the 6. So the assumption is you mean all of them.
Yes.
And now to explain that, presumably is where we get paragraph 8.
Yes.
You say this individual sent a threat to 1.
Yes.
Okay?
Yes.
Now, if you can just go to your affidavit, rejoinder, dealing with Dr. Besigye. Are you there?
Yes, sir.
So in that paragraph, you now talk, my Lord, paragraph 28. We have that joined down to Dr. Besigye. So in paragraph 28, you also make reference to threats.
Yes.
And now you say it is to some of the witnesses.
Yes.
So, would I be correct to say that from your evidence, the 3 paragraphs we have read, that we are not sure, you are not sure about whether the threats are to all, to one, or to some?
My Lord, I'm sure
Would I be correct
You're
to
not
make
correct.
that assertion?
You're not correct.
Is there a consistency between those three paragraphs that we have just read? Where you say one, where you say all six, where you say some. Is it your evidence that that is consistent reference to all?
Yes, my Lord, it is. Because
You don't have to explain. We have got, so just to be clear, paragraph 6, 7 and 8 of the affidavit in support, 28 make reference to all, despite these differences. That you
they are not different.
Now, would you just confirm that the use of the phrase security threat is not explained in your paragraph 7? The security threat, there's no explanation anywhere about what it is. Paragraph 7 of the affidavit support.
My Lord, we take the literal meaning of the word security threat.
I'm asking you,
It is self-explanatory.
do you give the instances of what that phrase means?
It
In
is
paragraph 7.
It is self-explanatory.
Please point out the instances that you have.
When I say security threat, we use the literal meanings of the two words.
We are not interpreting the statute, we are interpreting your evidence. Okay? You say they are security threats.
Yes.
I must.
Yes.
In the paragraph where you talk about the security threats, have you defined what they are?
My Lord,
Have you defined what they are?
the words are self-explanatory. I don't need to define them.
Is that a yes or a no?
It's a yes.
You have defined them.
By their words. By the words themselves.
So in paragraph 7, please read me the definition, what you have defined.
The security threats, my Lord, is self-explanatory.
Is it your evidence that it does not need expounding on?
No, it doesn't.
That's really hard.
And we have named the person threatening.
No worries. You also talk about the real threat,
Yes.
and you also talk about threatened harm in your affidavit. Again, have you defined any of those instances? Are they also self-explanatory?
Real threats by Kyomuhendo.
Are they self-explanatory? That's
The
the
real threats, yes, they are.
So is it your evidence that when you say real threats, the court is meant to understand what they are?
The real threats, my Lord, we talked about. I
Is it
talk
your
about
evidence-
Kyomuhendo.
Is it your evidence that when you say they are real threats, that is adequate for the court to understand what those threats are? And Mr. Kyomuhendo, bearing in mind, we've agreed on the burden.
Yes, my Lord, because we named the person behind the threat.
So is it your evidence that the person is the threat?
My Lord,
Mr. Kyomuhendo, is it your evidence that the person you name
the person
is the threat?
the person and the nature of the offense are the threats. The nature of the offense, this is a high-risk offense, my Lord.
Do you agree with me, Mr. Kyomuhendo, that you do not indicate anywhere the nature of the threat?
We indicate the threats by Kyomuhendo, then we indicate harm. Those are the threats.
Do you agree that you do not indicate anywhere?
I don't agree.
I haven't. Perhaps it's the physiology that you don't like. And I can rephrase. Do you agree in your 4 affidavits that you made that you have not given any instance of a threat?
I don't agree.
Could you point out the pointers for paragraph where you have indicated the nature of the threat, an instance of the threat? They are all bound together. I give them to you.
Paragraph 8, the investigation revealed date of the affidavit in support. The investigation revealed that Frank Chihehere, who is an accomplice to the respondent, threatened to harm one of the witnesses in this matter.
So is that an instance of the nature of the threat?
Yes, it is.
What is the nature?
To harm.
From that,
The nature of that threat is to harm.
what is the nature of the harm? According to what you have read, what's the nature of the harm which you call it?
My Lord, the harm is harm. Mr. KALIBBALA, I have answered your question.
Is there the nature of the harm described in that?
Yes.
How is that?
You see, I'm not a
If you are saying,
it is.
let us
I
say,
said to harm.
if you are saying that the nature of the harm is indicated in your paragraph 8,
I cannot classify the harm.
so it is not indicated.
Because I cannot
Okay,
classify.
so let's go back. Is it indicated here? Or?
There is harm. But I am not competent to classify harm, which type of harm.
Let's go back a little bit. Mr. Kyomuhendo. In your affidavits, the form, would I be correct to say that all the evidence that you intended to rely on was supplied for this application?
Not yet.
There is more evidence you intend to bring? Because I have talked about your 4 affidavits. Mr. Kyomuhendo, you are holding them there. I'm asking you to confirm that all the evidence you intended to rely on is in those affidavits.
In the affidavit?
Yes.
Yes.
And I would also be correct to say that you did not leave out anything. That is important.
No, I did not.
And the 2 documents that you intended to use are annexed to your affidavit in support. One is an ID, the other one is a right.
Yes.
And there is no other witness apart from you
There is.
that is coming to testify.
There is.
And you have not sworn any supplementary affidavit.
No.
So, would I be correct to say that all the evidence that you wish to use is the 4 affidavits and the 2 documents?
Correct.
Do you agree, Mr. Kyomuhendo, that a court of law can only rely on evidence that has been brought before you.
Yes.
So either party can bring evidence,
Yes.
so long as it is available.
Yes.
Do you also agree that if no evidence is provided, the court has nothing to act on?
True.
So in fact, it cannot act in a vacuum
True.
as far as the facts are concerned.
True.
And when we talk about evidence, we talk about facts required to prove what we are saying. For example, when you say, this is my position, the ODPP, we provided something to show that. Correct?
Yes.
So if that's really the meaning of evidence when we are asking for proof. Would I also be correct to say that all the relevant evidence, threats, so on, was accessible to you?
Yes.
I think you even referred to this file, which you can.
Yes.
So, would I be correct that if certain evidence is not available to the court, it's because either it's not accessible to you, or you deem it unnecessary for the court's decision, or it doesn't support your case? Would I be correct? Are any of those three assertions incorrect?
They are not.
So you are saying that you can avail evidence which is not available.
Sorry?
You
I
are
can't
being-
avail what is not available.
So let me ask you. This is the question. If evidence that is important has not been available, you agree that it may be because it's not accessible. Correct?
Yes, correct.
You agree that it may be because it's not relevant to your case.
No. I don't agree.
So you are saying that evidence which is relevant to your case can be kept away from the court.
Depending on the nature
Of that.
of the application.
We are not yet on the application, we're just talking.
Yeah, depending on the nature of the case and the nature of application or suit, whatever.
So do you agree that as the only witness who has come forward to support this application, that the duty to provide all credible evidence is square on that?
Yes.
Do you agree that if you haven't provided that evidence to the court would have no access to it?
I have provided it.
Say, do you agree that if a witness such as this has not provided,
Yes, I agree.
in other words, the court cannot go behind what they're doing here and get it correct?
No.
So we are restricting ourselves exactly what you have placed before the scope.
Yes.
Now back to our subject of security threat. Because, and you forgive me, Mr. Kyomuhendo, it may sound like we're going back and forth over it, but it's the basis of the application.
No problem.
So it's a fundamental point that we need to address. I just want to get your comments on a number of things about security. First of all, let's agree that from the evidence you have given, you have not placed before the court a specific security threat.
I have placed a specific security threat.
Would you care to
Paragraph
perhaps help me find it?
Paragraph 8 of the evidence report, which I have already read out.
Is that the one dealing with the word harm?
Yes.
So can we take your evidence to be that the specific security threat you have placed before the court is contained in the word harm?
Harm, threats, intimidation.
No, we are in paragraph 8, Mr. Kyomuhendo. That's the
Yes.
one. You pointed me to that specific one for the instance.
Yes.
We have agreed that the instance you are talking about is called harm.
Yes.
Right? So,
Yes.
can we just go back to where we started? Is it your evidence?
Before we go
Is it
there,
your evidence,
before
Mr.
we
Kyomuhendo?
go there,
Mr.
also
Kyomuhendo.
paragraph 10
We
is
are
referring to the
still,
same.
we are still at paragraph
Yes.
8.
Yes.
We're just going with what we are reading.
Okay. Okay.
The specific, see, I asked you for a specific instance, you referred me to 8.
Yes.
And 8, we have agreed on something else. The word harm is specific. So, can I conclude on that point? That a specific threat to all the 6 witnesses, as contained in your paragraph 8, is in the word harm.
There's also paragraph 10.
Mr. Kyomuhendo, we are not yet at 10, we are at 8.
It is not only in the word harm,
Well,
there is interference and intimidation together with harm.
We'll get to 10, we are still at 8.
No, I'm telling you.
Mr. Kyomuhendo, let's read 8. Read it out loud.
Yes.
Read it out.
Investigation revealed that Frank Kyomuhendo is an accomplice to the respondents threatened to harm one of the witnesses in this matter.
What is the instance of security threat
Harm.
in paragraph 8?
Harm.
Is there any detail of what the nature of that harm is in paragraph 8?
My lord, it is just harm.
Is it specified in paragraph 8?
I don't know what detail that you want. According to me, this is sufficient.
So is there a detail or not?
Yes, there is. The word according to me, harm is sufficient. Yes.
So let's get the words clearly. The security threat is called harm.
Harm.
Correct?
Yes.
Now, and it is the same one being made all the 6 witnesses. According to paragraph 8, all the 6.
Yes.
Again, in paragraph 8, show me where you make reference to the 6 witnesses.
That is canvassed in the affidavit in the
So you
rejoinder.
confirm in paragraph 8 you make reference to 1.
Yes.
Can we maybe agree on maybe a few more things? In your evidence, you don't show how the threats were made. You mentioned nothing about how they were made.
I mentioned how, yes, I mentioned how they were. I mentioned that they were made.
No, do you please listen to the question?
Yes?
I have read that you have said they were made.
Yes. Yes.
I am asking you that you have not stated
No.
how.
No.
Let's also confirm that you have not stated any geographical location from which they were made.
I couldn't.
Yes or no?
No.
The answer is no.
No.
In your affidavits, also confirm you have not stated threats to any loved ones.
No, I didn't. What I said,
No, the answer is sufficient.
my Lord, I mentioned that threats.
No, the answer is sufficient. We have left the threats. So now talking about loved ones.
My Lord, in paragraph 10,
Such a
in paragraph 10, I mentioned intimidation to the loved one.
When you finish, you can go back further. Because we are still at that.
My Lord, in paragraph 10, I mentioned interference, intimidation, and harm towards,
Let me know when you are done.
Towards- yes, I will let you know.
Let me go back.
towards the witnesses and their loved ones. Continue.
So can you confirm that there are no instances of threats to loved ones mentioned in your evidence?
In paragraph 10, I mentioned
What are the instances mentioned in paragraph 10 of harm towards the loved ones?
I mentioned
Please give us
I
breakdown.
still mentioned harm.
We are dealing with harm, Mr. Kyomuhendo.
I mentioned harm.
Harm to loved ones.
Yes.
So tell me the instances of harm to loved ones. Remembering that you told us earlier, you have not interacted with any of them.
My Lord, let's
Give us the instance. One,
maybe if you allow me to read
number
out.
one. Mr. Kyomuhendo, number
Let me read
one.
out paragraph 10.
No, number one, harm. Number one,
Harm.
the nature. Number one,
Harm.
the loved ones, specifically the loved ones. Nature of harm, number one.
It is harm.
The nature of harm is the harm.
It is harm. I can't classify it.
That the threats to loved ones is harm. That is good enough.
In paragraph 10, yes.
Now, such a method, when there are threats made to a person, what do you envisage can demonstrate such threats? If I threatened you and I wouldn't, what would you expect would be something that can demonstrate that I have threatened you?
If you threaten me, like,
Perhaps words, would words be something that can
yes,
be used to threaten?
yes, I can just say Mr. KALIBBALA threatened me.
So, no, hang on. Start. We were getting instances of what can amount to. Such a way, we are together.
Yes,
So words can be used to threaten. Words which are spoken can be used to threaten.
yes,
Words which are written can be used
yes,
to threaten.
yes.
Okay? In this instance, what was the nature of the threatening? How was the threatening communicated?
My Lord, I said it was electronic.
So they were words.
Yes.
And you read the words.
Yes.
And in your estimation, the words you read amounted to threats. Correct?
Yes.
Now, in your affidavits, do you anywhere reproduce any of the words?
What I captured was harm.
Do you reproduce any of the words you read which form a threat?
Only one word, which is harm.
Did you reproduce?
Yes, only one word, which is harm.
So it is your evidence that as you were reading through the police file, you came across the word harm,
Yes.
and you constituted that word to be a threat.
Yes.
Now, is there anything in the law that would have barred you from reproducing the exact words in this evidence?
Nothing bad.
So the choice not to reproduce those words and make them available to the court, for the court to assess their meaning, was determined, made by you. The choice to exclude those words, because the law doesn't bar you, so you could have. The choice was made by you not to avail the court with those words.
My Lord, I thought,
Yes, yes or no? The choice was made by you.
the choice was because of the nature of the application.
I'm not talking about identifying the people. I'm talking about identifying the words constituting the phrase.
Yes, my Lord,
So
that
the
was
choice to exclude that was your choice.
because of the nature of the application.
Don't you think that the need to protect the victims would have actually necessitated the availing of those words to the court, so that the court can assess how threatening or not threatening they are?
No, my Lord,
You don't think so?
no.
In your evidence, is there anywhere where the individual you name being the one you indicate anywhere anything about where he lives?
That would jeopardize the investigation because he's an accomplice.
Disclosing where the person threatening lives will jeopardize the investigation.
My Lord, I pray not to answer that question.
Is that your
Because,
no, you must answer.
my Lord, this is an accomplice that is even in the summary of the case. We can't go into that.
You see, Mr. Kyomuhendo, you are the one who brought the summary of the case as part of the ERNEST charge.
Yes, but it is
Supporting
between me. It is between me and you, not the general public.
Yeah, that's why it's me asking, not the general public.
Yes, but what I answer goes to the general public.
Yeah, so now you
And
answer.
it is yes.
So now you answer.
Yes.
Do you indicate in your affidavit where that individual?
It was not necessary because it would jeopardize.
So is it a yes or no?
It was not necessary.
Because I could also ask you the question, is it necessary?
It was not necessary. I did not
So
indicate.
now can you answer that?
I did not
Did you indicate where?
I didn't. I didn't.
Mr. Kyomuhendo, with all that has gone on, the past cross-examination, do you really still believe that you have credible evidence?
Yes.
Or the basis?
Yes, yes, we do.
And you believe you have provided it to the court?
Yes.
let's just go back. The threat, just quickly. The threat that you have told the court is the word harm.
Yes. My Lord, I don't know for how long I'm going to answer that question, honestly.
We are winding up on the point. So don't worry. You have not provided any voices, any words, any texts, or anything like that to specify those things.
I told you
It's a simple yes or no.
I beg your pardon, I have not.
You have not provided any
No.
voices,
I provided a word.
letters, any text. Kyomuhendo, what's going on?
Mr. Kalibala,
you are
I also have a right.
I
I have a right.
The court is the one in charge. I just saw you disappear. What was going on? And since we are talking about harm and threats.
Okay, I'm sorry, I should have I'm sorry.
So let me get this very specific about this. Camera focus. The way you want. Mr. Kyomuhendo, you confirm there are no voices, there is no text that is specific about these threats. We will take the word harm as sufficient.
Yes.
And in your estimation, that word is enough for the court to act and grant the order of sale. Yes or no?
My Lord,
Mr. Kyomuhendo,
there are other grounds.
the word harm. We are still on the word harm.
No, you cannot bind me that is only enough. There are other grounds.
We will get to those other words.
No. My Lord, this ground is alongside other
Is
grounds.
the word harm one of
Yes,
the words?
it is enough.
It is enough.
Yes.
The evidence is sufficient.
Yes.
Now, let's go to an area which I'm sure you are familiar with. As a prosecutor, you are familiar with the Bill of Rights, Chapter 3.
Yes.
Confirm we have Chapter 4 as our Bill of Rights. Let's just get the comment. The rights and freedoms in that chapter are inherent. They are not granted by the state.
No.
And you confirm that they must be respected, they must be upheld, and in fact they must be promoted by all
Subject to
organizations.
certain conditions for some of them.
Okay, let's read, let me give you a read. Maybe read Article 20, Sub-Article 2. And you especially highlight the part which says subject. As you were going.
The rights,
We have chapter 4.
We are in Chapter 4 generally, and now we are starting in Chapter 4.
the rights and freedoms of
Article 20. So 20 Sub-Article 2 says,
the rights and freedoms of the individual and groups enshrined in this chapter shall be respected, upheld, and promoted by all organs and agencies of government and by all persons.
now read the part which says subject to.
This is found in other articles.
We are on 20. Such a thing. We are on 20.
My Lord, this constitution should be read as a whole. Let us pass
Okay,
it.
Mr. Chom-
20.
Mr. Chom- Mr. Chom-
Yes, my Lord. Yes, close to.
Mr. Chom- does
Let me know what you want to
Does 22 have those words
No, it
subject
doesn't.
to anything?
That's it.
It says respect, uphold, promote.
Yes.
Correct?
Yes.
What does, now you as a lawyer, what does inherit mean?
God given.
God given. They are natural. You want to tell me more?
I don't know if they are natural. I'm told if they are good.
They are good.
If it is natural, then it is natural. If it is not, you tell me.
All right. So they are in both. They in both.
I told you they are good.
And these same rights are in you, in me, in the accused,
Correct.
including the court.
Correct.
So all of us are enjoined to respect them, to uphold them, and to promote them. Correct?
Correct.
Now, among the rights that are pertinent to this particular matter is where we have gone before fair hearing. It's one of those that is inherent.
Yes.
Correct?
Yes.
It is to be respected,
Yes.
upheld,
Yes.
promoted.
Yes.
Now, I will refer to these ones in 28 as fair trial rights, that's for us.
Yes.
Now, these fair trial rights, Kyomuhendo, we agree are not granted by the state.
No.
And specifically, in 28.3, we are dealing with those that relate to an accused person. Saying every person who is charged with a criminal offense shall agree. So we are dealing with the rights accruing to an accused person.
You read out for me.
Sorry?
I did.
I can read for yourself. I read for yourself. Article 28. I'm just interested in the beginning. Just for us to distinguish that it's the accused, not the state.
Yes.
So 28.3 are about the accused.
Yes.
Why do you think they are fair trial rights? Such a
We have fair trial rights because we as human beings, we ordinary people have to be protected.
So it's to protect us against injustice. Excesses, injustice. Now that we are using these words, can we also maybe just articulate them? When you talk about injustice, what are you talking about? As a law.
Like you subject to me to stand here for very long time.
I don't have the witness seat. Yes, please sit. I don't want to subject you to stand for a long time. You sit. I don't want to cause you an but perhaps he was joking.
No.
He said, because you are injustice by subjecting you to stand. That's why I asked him to sit.
So, their brain.
So, the meaning of injustice is where we are. What does it convey to you? So, Mr. Kyomuhendo, let's go back to our injustice.
Yes.
You agree that if you deny somebody a right they have, that's unjust. It's unfair.
It depends on the situation, on the circumstances.
Okay, so if you denied the Article 28.3 rights, that would be an injustice. Correct?
I need to look.
No, I gave you an image.
No. I need to.
It would be an injustice if one was denied those rights in Article 28.
except for the exclusion of the right to disclosure. Yes.
We haven't even reached that part. I'm just asking, would it be unjust to deny a person their right, such as the one in Article 15?
Yes, it is.
Now, in a number of paragraphs, Mr. Kyomuhendo, you mentioned that the orders sought will not cause injustice. Okay? You remember those paragraphs?
Yes.
Refer you to maybe paragraph 12 of your affidavit in support.
Yes. They will. My lord, the order sought will not occasion a miscarriage.
I'm talking about an injustice.
Yes, an injustice and a miscarriage.
Miscarriage are
Okay.
different things.
They will not occasion an injustice. They will.
And you are confirmed that you say that.
Yes, I say.
You have done
Yes.
various places.
Yes.
So, when those rights are withheld, there will be no injustice.
I beg your pardon?
We are just continuing from your earlier assertion just now. So if those rights are withheld, there will be no injustice.
If the rights are withheld, there will be injustice.
There will be.
Yes.
Is the fair trial rights that article? Is it one which is among the four from which there cannot be any derogation?
Yes.
The derogation is what we talked about earlier in Article 44.
Yes.
Can you just read the beginning words of Article 44 so that we have the two in context?
Article 44 is prohibition of derogation from particular human rights and freedoms.
So it's a prohibition, first of all,
Yes.
correct?
Correct.
Now read the beginning words.
Notwithstanding anything in this Constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. Freedom from torture and cruel, inhuman, or degrading treatment or punishment.
Yes. So read the detail. But let's just confirm under Article 44, there are no circumstances within that article that says you can depart from
No.
fair hearing.
No.
In fact, it's a prohibition.
Yes.
And the only place it makes reference in emphasizing that prohibition is any other part of the Constitution. Correct? Notwithstanding any other part of the Constitution.
My Lord, I'm not so sure because...
Read it. It's there.
No, what
just
I'm...
read it.
Not which one? What do you want me to read?
The beginning word of Article 44.
Notwithstanding anything in this Constitution, there shall be no derogation from the enjoyment of the following
So I'm
rights.
asking you to confirm that those words make reference only to the Constitution in emphasizing the
Yes,
prohibition.
yes. Yes.
No other instrument, nothing else.
No.
So within the Constitution, there cannot be anything that allows derogation.
No.
Correct?
Correct.
So the Constitution is clear. You can't depart from Article 28.
No, you can't.
When you depart from Article 44, you depart from any of those rights where there is no derogation. What is the consequence?
What do you mean by departure?
When you derogate?
Like which
Well,
particular...
let's go back.
Like which particular aspect?
Let's go back. Mr. Chuma.
Yes.
We agree that there is a bar, there is a prohibition from derogating from those rights?
Yes, there is.
What does derogation mean?
Derogation means when the right can be denied or violated.
So let's agree there are no instances, according to Article 44, where those rights can be denied. Correct?
Like which rights?
The ones in Article 44.
According to the Constitution, no.
And we remember the Constitution is supreme. It governs all of us. It
Yes.
binds all of us. We must
Yes.
abide by it. Correct?
Yes.
Now, if you just go to your affidavit you joined again to Dr. Besigye's evidence.
Yes.
If you go to paragraph, this is paragraph 3. That affidavit. I share the set with you, sir.
This?
Yes, that whole set is for you to use. But
Yes, paragraph?
Paragraph 3.
Yes.
Are you there?
Yes.
Just read it, you say it.
Paragraphs 4 and 5 of the first applicant's affidavit in reply are denied.
When you say they are denied, what do you mean? What are you asserting?
That he will have to prove. He will have to be put to strict proof.
You are not saying that they are not true. What you are denying, you are not saying that what you are denying is not true.
I'm saying he will be required to prove.
Do you include the words will be required to prove?
No.
So when you say denied, is it correct that you are saying the assertion is not true?
Which paragraphs?
That one. You are
Well, no, I don't have his.
we are on the word denied.
I need no. I need to know the paragraphs I replied to.
We are
I
still on the
rejoined.
word denied. We are going to go to those two paragraphs.
No, but you see, it is not fair for me to take me to this paragraph without.
You see, paragraph 3, you are just understanding the meaning of the word denied. It says, this paragraph, that affidavit is denied.
Yes, but I need to
Why
first
you
look at
understand what it
paragraph.
means?
You see, Mr. KALIBBALA, you need to be fair to me because I need to know the paragraphs.
I'm trying to be as fair as I can.
No.
How do you prefer
They
that?
have paragraphs.
Of the affidavit in joint. That's where
What did you state?
That paragraphs 4 and 5 of the first.
That paragraph
4 and 5
5.
of the first applicant's affidavit in reply are denied.
Yes. So I was asking you, because I don't want to be unfair.
Yes.
I was asking you when you use the word denied, because you use that word in several paragraphs in your rejoinder. Do you mean that what you are responding to is not true? That's all I'm asking.
It is not true, according to me.
So now, let's go to paragraph 5 of Dr. Besigye's affidavit in reply, because you responded to it as we have seen. Now, my own paragraph 5 of Dr. Besigye's affidavit in reply. So paragraph 4, you respond and say, what is asserted there is not true, correct?
Yes.
Are we in the same, are we working together?
Yes.
So paragraph 4, Dr. Besigye says is a former presidential candidate having stood for the position 10 years ago in 2016. Your response here is that it's not true.
Yes, it is.
It's not true. How many times has he stood as a president?
I don't know.
You want this court to honestly take that answer, Mr. Chokwe?
Yes.
But you can only assert that it's not true because you have an alternative fact. So what's the alternative fact? How many times has he stood?
I remember seeing him in
Mr.
two.
Kyomuhendo, how many times has he stood?
I can only attest to 3.
3 times.
Yes.
Which year and which year and which year?
2016.
So let's stop at 2016.
Yes.
He last stood in 2016. According to you, it is not true.
The number
Now
of
you are
times.
telling me here that he stood in 2016.
The number of times. He said 5 times. Me, I don't know about the 5.
The 5 times?
Yes.
Mr. Kyomuhendo, read paragraph.
Oh,
Of his affidavit. Maybe you have a different one. I'm a former presidential candidate, having last stood for the position 10 years ago in 2016. Where is the 5 times? Are we reading a different document? Mr. Kyomuhendo, that's the one. Paragraph, Mr. Kyomuhendo, let me guide you. Let me guide you. We started with your affidavit.
yes.
Joining.
Yes, yes.
Where I pointed out that you are responding in your paragraph 3 to 2 paragraphs of Dr. Besigye's affidavit reply. We are now at those 2 paragraphs, paragraph 4, paragraph 5. Are we there now?
Yes.
So, in paragraph 4, it says he's a former presidential candidate. He last stood in 2016, 10 years ago.
yes.
Your answer is it is not true. So I am now asking you, what is the basis of your conclusion that that assertion in paragraph 4 is not true? Or were you responding untruthfully to that
Well,
assertion?
Not necessarily, my lord.
What's the basis of your answer that is not true? You have just ascertained when you use the word denied, means not true. What is the basis?
I said, when I said denied, I meant,
No, you didn't mean. You have
my lord, what I
explained
meant was
No.
he will be put to strict proof.
No.
Yes.
Mr. Kyomuhendo, do you say that in your paragraph? That he'll be put to strict proof?
I'm now explaining it.
Do you put it in your paragraph?
I'm now explaining. I did not. I did not.
You didn't.
I did not.
So, is this assertion in paragraph 4 correct?
Yes, it is.
He was a presidential candidate.
Yes.
He last stood 10 years ago in 2016.
Yes,
That is a fact.
it is.
Let's go to paragraph 5. Paragraph 5 is another one which you have said is not true. Let me read out paragraph 5 to you. Mr. Kyomuhendo, are you paying attention?
Please read. I'm also going there.
Paragraph 5 has 2 sentences. The first one is about service in various capacities. I will leave that one. I'm interested in the second one. Are you at the second one?
Which one?
As a citizen of Uganda, such a line 4, paragraph 5 of the affidavit reply. Are you there?
Not yet.
I had arranged those things for you so that they are easy to find. You may have.
It would have been better if it had been split.
But we
Yes, you
can-
said
we can
paragraph?
split them. Paragraph 5
Yes.
is Dr. Besigye's affidavit. Are you there?
Yes.
So there are 2 sentences there. I'm interested in the second sentence. It starts with the words, as a citizen of Uganda. You see those words?
Read it.
Read it out.
Yes. Can you please read us those words, as a citizen of Uganda?
That I have served in.
No.
Mm.
I'm talking about the second
Can I hear the entire paragraph 7, 5?
paragraph 5. I can read it out.
Yes.
That I have served Uganda in various capacities. I am a responsible citizen of Uganda who has always advocated for and pursued peaceful means to ensure that Uganda is governed in accordance with the law and constitutional dictates. Second sentence, as a citizen of Uganda, I am entitled to enjoy all rights accorded to citizens as well as to participate in all lawful activities as an individual as a leader, including within the political formation in which I belong and whose ideology I subscribe. So I am now at the second sentence, as a citizen. Are you there, Mr. Chairman?
Yes, I'm there.
Dr. Besigye asserts his entitlement to enjoy all rights. Correct?
Yes.
Your response to that assertion is that it is denied.
Yes.
So you are saying that Dr. Besigye's rights are not inherent.
Not that.
They are granted by you.
No. My Lord,
Mr. Kyomuhendo,
not all rights are absolute
Mr. Kyomuhendo,
in the Constitution.
does Dr. Besigye have an entitlement to enjoy all rights according to statute?
Subject to, I can say subject to the Constitution, some rights may not be available in certain circumstances.
So you are saying that he's not entitled to enjoy all rights.
Certain rights, depending on the existence of certain circumstances.
So are you, hey, let's go back to where we started. Are you asserting that his rights are not inherent?
Those are your words.
I'm asking you.
Those are your words.
I'm asking you. And I'm asking
I
you
have not
seriously.
said it.
And I'm asking you to answer.
I have
Are
not
you
said it.
asserting that his rights are not inherent?
We all
Are
have
you-
inherent
are you
rights.
asserting-
His rights are inherent but subject to certain conditions.
Whose rights are inherent?
Doctors.
So now state it. Are his rights inherent?
Subject to certain conditions.
Such
Yes.
as?
Like
Remember where we started? We
law,
started
like
in-
law enforcement.
Hold on. We started in Article 20, which you read for us.
Like law enforcement.
Like?
Law enforcement.
Please explain.
Where someone is, where a citizen is accused of committing or suspected of committing a crime,
Yes.
we can be arrested,
Absolutely.
and detained, charged, and remanded.
Absolutely.
Yes. Where there is a trial of such a nature, we can pray to court to conceal the identities of certain witnesses.
You are in a hurry to get to the...
No. You asked. You wanted to know the circumstances under which.
So now let's go back. Let's go through.
Yes.
So Article 23 is about the arrest.
Yes.
Right?
Yes.
Certainly, arrest can be interfered with.
Yes.
I mean, liberty can be interfered with.
Yes.
Is liberty of Article 23 part of what is in Article 44?
No.
So it can be derogated.
Yes, it can.
Okay?
Yes.
The ones which we are dealing with are in 28. Can they be derogated?
28? No.
So he's entitled to them. The accused persons are entitled to all the rights in Article 28.
Yes.
And we have no choice but to observe those rights.
And they
In
are
fact,
being,
to promote them.
they are being observed and promoted.
That's your view. We have no other obligation but to promote them, to observe
And
them.
they are being observed and promoted.
Is it your evidence that this application is an example of promotion of those rights?
Yes. It is.
When you say that these rights can be denied, the ones that he says is entitled to enjoy, does that include the presumption of innocence?
No.
Sorry?
No.
Does it include being granted facilities to prepare for his defense?
No.
Does it include being given adequate time prepare for his defense?
No.
Do you agree, Mr. Kyomuhendo, that full disclosure promotes those rights? It's simple, yes or no? Do you agree? This one which you have said you can't deny. Do you agree that full disclosure promotes?
Depending on the nature and circumstances.
Yes or no? Do you agree?
Yes, I agree.
So full disclosure will assist an accused person. Correct?
Correct.
It will be useful in cross-examination.
Correct.
And that cross-examination is intended, among other things, to impeach the witnesses.
Correct.
Also to test the veracity of that witness.
Correct.
It is also important to discover who the witness is and their position in life.
Not always.
Do you know whether it's in the law or it's not?
It is in the law.
It's in the law.
Yes.
So it is useful for that purpose.
Yes, it is.
And in fact, the law allows it for that purpose.
It's not expressly stated in the Constitution.
Now let's go to the evidence side. We are now with the evidence side.
Yes.
We are dealing with cross-examination and witnesses. Okay?
Yes.
So one of the purposes, as we have agreed, is you are impeaching the witness, you are testing veracity, but you are also discovering the station.
Yes.
You agree?
I agree.
And you are also discovering their position in life. You agree?
I agree.
To be able to do those things effectively, full disclosure is necessary. You agree?
Yes, I do.
Now, I want to just close off on the point around the derogation and non-derogation, Mr. Chairman. It appears to me, and I would like to get your view about it, that our Constitution treats derogation extremely seriously. You agree?
Yes, I
It will
agree.
depart from those rights where it has said you can't. It treats that kind of thing very seriously.
I agree.
Are you familiar with the law called the Human Rights Enforcement Act?
Yes, I am.
Are you familiar with what it says about derogation?
Yes, I am.
What does it say?
Well, derogation from the rights in Article 44 can cause to nullification of the tribe.
Okay, that's part of the effect. That can be
Yes.
part of the effect.
Yes.
Do you agree that there is an offense created when you derogate from those rights? If you don't remember,
I
can-
don't remember.
I have the act here, unfortunately. Let's read section.
But these cameras are smart. Can't you let us concentrate? Stop those photos. You take them.
Which section?
Section 11. I don't we are section 11. This is my right section.
Section 11, derogation from non-derogable rights and
11.
freedoms.
We are section 11. We are now reading 11.1.
Derogation from non-derogable rights and freedoms. It is an offense for a person to derogate from non-derogable rights and freedom guaranteed under the Constitution.
So the Constitution says don't even dare.
Yes.
That law even makes it an offense. Don't close. We are still there.
I've already closed.
Okay, we shall read this.
Yes.
So the section makes it an offense to derogate from those rights.
Yes.
What is the penalty in that law for that derogation? Then let's give you the law so that we read it together. Look, we are looking at 11.6.
A person who commits the offense determined under subsection 1 is liable on conviction if no sentence is prescribed by law for such a violation to imprisonment for a term not exceeding 15 years.
So there is an offense and there is a penalty of up to 15 years
Yes.
if we derogate from these rights.
Yes.
Now I just want to understand this application in that context.
Yes.
We have established that Article 44 says, don't you dare.
Yes.
And it makes specific reference to Article 28.
Yes.
There, here. Correct?
Yes.
So if we act outside Article 28, it would be fair to say one is derogating from that right. Yes or no?
Depending on what is being done or not being done. Kindly be specific.
Is it possible to derogate from Article 28.3?
Kindly, what kind of derogation? That's what I want you to.
You know, you are the one who told me what derogation means.
Yes.
You remember?
Yes.
So now applying your definition of derogation.
Which aspects?
Listen, it
Yes.
would be wise for you to listen. Article 28, we agreed, deals with the rights of accused persons. Correct?
Yes.
I am asking you, are there circumstances where those rights that go first I look at
Guys, please take off your camera as I take my break.
I was asking you whether any of those rights in that sub-article can be derogated from.
No.
So earlier on, it was established that we don't have a specific legislation dealing with witness protection.
We do have, but they are scattered.
So you agree with me that it's an area which is not clear in the context of our jurisprudence?
The area is very clear, my lord. Very clear.
In our jurisprudence?
Yes. It is you who doesn't want to understand it, but it is clear.
Okay, so let's start with the Constitution where we get it from. Where it's clear in the Constitution. Let's start with, because it's clear, let's start with where we get it from.
Yes.
The Constitution.
Yes, what do you want me to do?
I thought you were pointing us to where we derive it. You said
It is
very
part
clear.
of, it is part of, it is one of the tenets of the fair trial.
Okay. Yeah, just point us to the article and read it out so that we are clear. Because it's clear.
My lord, like I earlier on said, this
No, the article is such a
Article 28, it is one of the tenets.
So read us the tenet that deals with what you are asking.
This has been interpreted in case law.
No, read us the article that says it's a tenet.
It's a tenet of the right to a fair hearing. It is part and parcel
So to help
of a
you,
fair trial.
to help you so that the evidence is clear, are you saying that witness protection is one of the rights captured in Article 20?
As interpreted by the Constitutional Court.
Are
Yes.
you saying it's one of the rights captured in Article 20?
As interpreted by the Constitutional Court in the case of Soon Yoon Kim versus Attorney General.
Oh, you have brought us back to Sue.
Yes.
I remember you. So I just want us to be clear of your evidence.
Yes.
And let me ask specifically, is there in that article any mention of witness protection?
My lord, this article was interpreted.
Is there in that article? We are not,
And I'm telling you, this article was interpreted by the Constitutional Court.
Yes, Mr. Kyomuhendo, we can read the
Okay, no. No.
Is there
Expressly, it is
an
not
express?
here. It is not here expressly.
Let's go to soon where you want us to.
Yes.
And you recall soon was about to advance the school.
Yes.
Because previously, trials were fully by ambush. Correct?
Yes.
So, soon set the law to be that an accused is entitled to
Disclosure.
disclosure.
Yes.
Okay?
Yes.
Was a counsel in that case, why don't you ask him to tell us?
I look like packed some questions.
You will help us, don't worry.
So that's one of the things that arose. In fact, it's what is frequently referred to. It is
Yes.
used to support this disclosure. Correct?
Yes.
Now, you were saying that in that case, Article 28 can be derogated from.
Not a derogation per se, but this disclosure is part and parcel. It is an exception.
So let's go back. Article 28 cannot be derogated.
No, it can't.
So Article 28 has no exception.
It has exceptions.
Exceptions mean that you derogate from it. Correct?
Not derogation,
Exceptions mean you derogate from it.
not derogation, but for this particular right of to be given adequate time and facilities for the preparation of his or her defense. This was interpreted by the Constitutional Court.
What did the court say about
That
about what you are seeking to do here?
court said that witness protection is not absolute. It is subject.
Such a way to go slow.
Sorry.
Try and go
That
slow.
witness protect the right
Together.
to. Sorry, the right to disclosure is not absolute.
Yes.
It is subject to certain conditions, like protection of state secrets, protection of informers, and witness protection.
And was that statement by the court subject to anything?
Of course, it is subject to the discretion of court.
Beyond the discretion of the court.
It is subject to the discretion of court and upon proof.
So there is an element of proof.
Yes,
In fact, the court said subject to evidence.
yes,
Correct?
and discretion, yes.
So I want to ask you again, in your view, the evidence that you have brought suffices?
The evidence is very sufficient.
Mr. Kyomuhendo, is disclosure and witness protection the same?
I can say yes.
So this advanced disclosure and witness protection are the same, according to Mr. Kyomuhendo. Let's go to your, as we wind up, go to your affidavit later. Would I be correct to say, because you were very specific in your responses, you tackle paragraph by paragraph and so on. Would I be correct to say that where you make no mention of an assertion, you are accepting that assertion? Where you don't explain it, don't deny it, you are accepting it
Yes,
as correct. Would I be correct?
yes.
Paragraph 18 of your affidavit in the joinder when you say that witness protection for the one of Dr. Paragraph 18, you say that witness protection is inevitable in the circumstances of this case.
Yes.
Okay, I want to understand, particularly your choice of words. When you say it is inevitable,
We cannot do away with it. It's very important, it is crucial.
so it must be given.
Sorry?
It must be given.
That is
If
what,
it's inevitable, it's must be given.
you want to make me like as if I'm directing court. I say it is subject to the discretion of court.
I'm reading the words that you use.
This is my assertion, but it is subject to the
I am
discretion
reading
of
the
court.
words that you use and I'm asking you questions.
According to me,
Yes.
yes.
So it must be given.
Yes.
Just to make it clear, it cannot be denied.
Sorry? Mr. Kalibbala, I said it is the discretion of God. Yes.
We have understood you to say
It should not be denied.
let's go to paragraph 20. Paragraph 20. Are you at your paragraph 20?
Yes.
Paragraph 20 of your affidavit is joined up is responding to your affidavit Dr. responding to paragraph 23 of his affidavit in reply.
Yes.
Right?
Yes.
And in that affidavit in reply, he makes a number of assertions. Have you seen this?
Please read for me.
You have it open and read. You have to stand up, open and read.
My Lord, I'm tired. Please read for me. My head is I'm getting
Mr.
tired.
Kyomuhendo, open page 3 of that affidavit. Your affidavit in reply and you start from there.
I am here.
You are there?
I thought you were telling me to
So
open
paragraph
another.
20.
Yes.
Now you will read paragraph 20 together with paragraph 23 of Dr. Besigye's affidavit in reply, which you have there, which you will open.
That in reply to paragraph 23 of the applicant's affidavit, the charges and circumstances are different from the previous charges.
So let's go to paragraph 23
Paragraph 26
of Dr. Besigye's affidavit in reply, which you have, which you shall read. Are you there?
Yes.
So in paragraph 23, Dr. Besigye asserts that he has been charged with treason before,
Yes.
2005 and 2016. Correct?
I'm only aware of 2016.
At least you are aware of one of them.
Yes.
Because in 2016, Mr. Kyomuhendo, it is public knowledge that he was charged. But
That's
now I'm
right.
putting it to you that in 2005, he was also charged. You are aware.
Yes. You will inform
You
you.
are aware.
Yes, now I'm aware.
Do you have any contrary information?
2005 I was at Los, I was
You were still
in school.
But those are the two occasions.
Yes.
On those two occasions, he asserts that in none of the proceedings was there trial in camera, witness anonymity, concealment, restriction of disclosure, and so on. Okay?
Yes.
Do you deny his assertion in your paragraph 20? Does your paragraph 20, which is responding to his assertions, deny those assertions?
Paragraph. I said that in reply to paragraph 23 of the applicant's affidavit.
Which we have just read.
Yes.
Now I'm asking you, do you, in your paragraph 20, have you denied any of these assertions? As far as trying camera, anonymity, concealment, restriction, have you?
I did not.
Just to be clear, so that we understand what it is. Do you know if the offense of treason in 2005 and in 2016 and in 2025 is the same offense called treason?
But it is treason.
It is treason.
Yes.
So it is the same offense.
It is the same offense.
And we have agreed that in the previous two, there was nothing about witness protection.
Yes.
Now you go to I want to go to your paragraph 29, Mr. Kyomuhendo. We have about 3 or 4 to finish. So just for you to be comfortable. Are you there, Mr. Kyomuhendo? Paragraph 29 of your affidavit, did you join that?
Yes.
So this to Dr.
Yes.
You are there?
Yes.
You are responding to his paragraph 30.
Hold it.
You are responding to his paragraph 32, correct?
Yes.
So in paragraph 32, he asserts that you have not demonstrated any real, credible, or imminent threat. Real, credible, imminent threat. Okay?
Yes.
In your response, do you deal with his assertion about a credible threat?
That is paragraph.
We are dealing with your 29. We are reading it together with Dr. Besigye's 32.
Yes, I responded and said,
Yes. Where did you respond to his assertion that there is no credible or imminent threat? In your paragraph 29.
let me read it out.
Yes.
That in reply to paragraph 32 of the second applicant's affidavit,
Yes. Yes.
the threats faced by the witnesses are real and not speculative as he wishes this honorable court to believe.
Who is the first applicant that you are referring to in that paragraph? Who is the applicant you are referring to?
It was in, I was referring to Dr. Besigye.
Who is the applicant in this matter?
I was referring to Dr. Besigye.
No, you say the applicant. Did you not?
This is a typo.
It's a typo.
Yes.
Let's go to maybe. So back to the question. Did you deal with his assertion that there is no credible imminent threat
Yes, my lord.
by saying that the threats are real?
Yes.
That's fair enough.
It is.
No, I'm saying it's fair enough. I'm saying the answer is fair. Paragraph 32. Let's move down a little bit. Are you at paragraph 32?
Yes.
In paragraph 32, you are responding to Dr. Besigye's paragraph 34.
Yes.
Right? Just read us paragraph 32 again. Read it out loud. Your paragraph 32.
That in reply to paragraph 34, whereas the state is protecting its citizens, some of the witnesses are vulnerable and susceptible to threats the moment their identities are disclosed to the applicant and public.
So the threats that those witnesses would suffer would arise from disclosure to the applicant.
In addition,
You agree that the threats would arise from disclosure to the applicant.
In addition to the threats that they have received already.
Lastly, do you agree that the state is adequately equipped and has the necessary security apparatus to ensure safety of persons in Uganda, including witnesses?
Of course, the state can protect.
Do you agree that the state is adequately equipped?
I don't know.
Are you saying that the state is not adequately equipped?
I am saying I don't know.
So if an order of the nature you are seeking was given, would the state have the capacity to enforce it? Because we just agreed you don't know the state's capacity.
My lord, these are simple mechanisms that do not require resources.
Would you?
Yes,
It would have.
yes.
So let me go back to the question. Does the state have adequate security apparatus to ensure safety?
My lord, I am not sure. I don't know because what we are asking for, these are simple witness protection mechanisms.
Sorry, your answer was?
I said I don't know.
Well, you don't know whether the state has adequate capacity.
No.
So you are not sure, we can also then conclude that if the order is given, you are not sure that it will be enforced.
This order will be enforced.
Using which capacity? By who and using which capacity?
My lord, reduction does not require money. Use of a code sheet and code names does not require money.
Do you understand when I say enforced?
Yes. These mechanisms will be enforced from court. I don't know.
Is the court not part of this?
The court always distances itself from the state.
So it is sitting somewhere in the back. Lastly, Mr. Kyomuhendo, I think let's just get some view about how the first order will work.
Which one?
The first order you see.
Concealment.
So it's on the cover page.
Concealment of the identities and non-disclosure of any material that is likely to reveal the identities of the 6 witnesses, witness A, B, C, D, E, and F. prior to the testimony.
Will those witnesses appear physically in the court?
Yes, they will appear. If they are within the country, they will appear.
Do you intend to have any of them not appear physically?
Unless the circumstances change, we intend to have them in court.
Beyond the 10 witnesses that we are aware of, we have 4 whose identities are disclosed. We have 6 who are the subject of the subpoena. As part of the prosecution team, that's what you said you are. Are there any other witnesses that you intend to call?
My Lord, I'm no longer part of the prosecution team.
Mr. Kyomuhendo.
I am no longer.
Mr. Kyomuhendo.
Yes. As of that time. My Lord, I need to consult my lawyer. I need to consult my lawyers as whether more than 10 witnesses will be
Do you
summoned.
have any affidavit that says, from you that says you are not part of the prosecution?
I'm on oath.
Do you have any?
I'm on oath. That is why I took oath.
Or you are saying when you take oath, you are deliberately to depart from the earlier oath?
No, that was that time. Circumstances have now changed.
So now I'm asking you,
Yes.
are there other witnesses?
I need to consult my lawyers.
Beyond the 10.
My Lord, with the leave of this honorable court, let me consult my lawyers.
I think you say that by the time we find this, we don't know whether they have other witnesses.
No, I said by the time I filed the affidavit, I was still part of the prosecution.
When did you cease to be part of the prosecution?
I ceased when we took a decision the day.
When did you cease? When is the date?
The day I came to this dock.
That's when you ceased.
Yes.
On the 23rd of April,
Yes.
you ceased to be part of the prosecution.
Of the prosecution team.
Did you have an opportunity since that time to file something to clarify that position?
I'm saying it on oath, my Lord.
Did you file anything to clarify that position?
I am saying
I'm
it
just
on oath.
asking.
No, I didn't, but I'm saying it on oath.
You did not. So were you part of the prosecution team before you took the stand or after you took the stand? On the 26th, on the 23rd.
The day I deponed the affidavit.
So on the 2nd of March, when you deposed the affidavit,
Yes.
you ceased to be part of the prosecution team.
Yes.
And that same affidavit says that I am part of the prosecution team.
The day I deponed,
Sworn at Kampala by the said KJ this 2nd day of March 2026. That's when you cease to be part of the prosecution team.
my Lord, if I may clarify.
No. Mr. Kyomuhendo.
Yes.
The day you deponed is 2nd March.
Yes.
You cease to be part of the prosecution
My Lord, I
team
deponed the
on the 2nd of March.
I deponed the 2 affidavits.
I'm dealing with the first one. Did you state that in your affidavit you joined?
No, I'm stating it on oath right now.
Was it in fact contested that you are part of the...
No, it's not contested.
Was it contested?
It's not, but it is just prudent that I step down.
So when you were being cross-examined on the 23rd of April,
Yes.
and you confirmed that you are part of the prosecution, you were not being truthful.
As of the time I made the affidavit. As of the time I made the
So,
affidavit.
let's get the dates.
Mm.
You deponed on the 31st of March.
Yes.
You testified on the 23rd.
I deponed the 2 affidavits.
Yes. The second one, second set
Yes.
was on the 31st of March.
Yes.
Okay. You testified nearly a month later.
Yes.
At that hearing, you confirmed that you were part of the prosecution.
As of the time of deponing the affidavits, my lord.
As of the day you are being prosecuted.
No, no. Mr. Mpanga, that day we started by you coming up by saying I'm an expert, blah, 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 blah. Yes. Yes. You what?
Wait for question.
So, Dr. Besigye said in his affidavit, and you said it wasn't contested.
Which one?
In Dr. Besigye's affidavit, he said, I have no knowledge about the affidavit of KJ or his being part of the prosecution team. Look at paragraph 12.
Yes, I have. I know it. I know it.
Check.
Paragraph what?
Paragraph 12 of Dr. Besigye's affidavit reply. Have you seen it?
Yes.
He said he had no knowledge of you being part of the team.
Yes.
Right.
Yes.
Now, in your paragraph in rejoinder, paragraph 7 of your
Yes.
affidavit rejoinder,
Yes.
you say that in reply to paragraph 12,
Yes.
which we have just read,
Yes.
I confirm that I am part of the team that was assigned to prosecute, and you describe the...
My lord, as of
Listen,
Mm.
Mr. Kyomuhendo, are you part of it?
right now,
We have just read your...
As of
this
that-
English is very clear.
as of that
It is
date,
not saying I was part. It is saying I am.
I was as of that
Such
date,
a present continuous. I am.
as of that date,
Not
I was.
past tense. I was.
My lord, an
So I
administrative.
am asking you now.
Yes. Yes.
On the day you testified,
Yes.
and now, are you not part of the prosecution?
I'm no longer part of
Do
it.
you have any evidence to show that you are not?
My lord, these are internal issues.
Do you have any evidence?
Just like I have no
Do you have
evidence.
any evidence, Mr. Kyomuhendo here?
My
that you
evidence.
ceased to be
My word.
part of the prosecution?
My word. Right now, I am no longer part of the team.
So back to my question.
Yes.
Do you know if it is the 10 or the 11?
Sorry. If the what?
You know where we started?
If it is there?
The 10 witnesses or the 11? You know where we started?
Yes.
We have come
My lord, I need to consult.
I have reported that you don't grant the mortgage, whether they will call more.
Thank you, my lord.
That's it. Yeah. I know that's it.
I wanted to enforce